Hello and welcome everybody. In this video, we are going to discuss the chapter on the law of contracts. This is part B of the subtopic Topics of Law. It's the second unit in your textbook. First of all, in India, any matter about a contract is governed by the Indian Contract Act of 1872. You must not confuse between these two laws, Indian Contract Act of 1872 and the Transfer of Property Act, which was relevant in your previous chapter, which was passed in 1882. There is a 10 years gap between the two. Now, what is a contract? An agreement that is enforceable by law and which is created with the intention to create a legal relationship can be termed as a contract. All agreements are not contract. Agreements must meet certain criteria. First of all, there should be a consideration. We already know that consideration means something in return. If I am giving you something, you must give something back to me. That's consideration. The parties to the contract must be competent. There should be free consent between parties. The contract should be for a lawful object and should be for a lawful consideration. And the contract should not be declared void by any law in force. Along with that, agreements that are created with a legal intention, there should be an intention and mindset to create the contract, then only an agreement can be considered to be a contract, otherwise not. Now there is an important case law here, Balfour versus Balfour, which speculates on the importance of this mindset and intention to create a legal relationship. What happened here? There is a question on the validity of agreement between the husband and the wife. There was a couple who went for a vacation abroad and the wife fell ill in England. The doctor asked her to take rest. After some days, her husband had to return to Ceylon where they lived and where he was employed. But she couldn't come back because she was ill. Now the husband promised to pay her a certain amount of money from Ceylon so that she can continue with her expenses at this place. But what happened? Because of some misunderstandings and some problems between them, the husband stopped sending the money after some days. Now the wife initiated a suit to recover the money from the husband, but the court's decision was that the agreement between the husband and the wife was merely a moral obligation. It was simply a moral obligation. There was no intention as such to enter into a legal relationship. That's why we cannot really consider it a contract. The wife didn't get the amount from the husband subsequently. Now, making of an agreement, general principles. There are certain things here. It's like an index. It's there in page 38 in the form of a figure. After we complete the entire chapter, we will come back here to see whether we have completed everything or not. So you can see the first thing here is offer. So let's do offer. What's an offer? Offer means when one person signifies to another his willingness to do or not to do certain things. It's called an offer. I want to sell my house to another person. I offered this to another person, to the second person. Now the second person, the person to whom I have made the offer, that person has to either accept it or reject it. If the person gives an assent or a consent to my offer, then it's called acceptance. And acceptance by the offeree has to be communicated back to me. It's mandatory. Both the offer and the acceptance must be legible, it must be definite, and it should not be uncertain and illegible. Offer plus acceptance. When there is an acceptance to the offer, then only there is an agreement. It should be clear too. Now, there is a very important case law here. Carlyle versus Carbolic Smoke Ball Company. What happens here? There was this Carbolic Smoke Ball Company It was the manufacturer of a medicine called smoke ball, and the medicine was used for treating influenza. Now, this is a very interesting case. When I did the chapter, I also got a project, and it was there. This case was there in my project. This was an important case in terms of any types of contract law, because an important concept emerged in the aftermath of this case, the concept of general offer. What happened here? The company said it gave an advertisement that the smoke ball medicine can cure influenza absolutely. So the company put up an advertisement offering a reward of £100 to anybody who got influenza despite using the medicine continuously for 15 days according to the directions. And £1,000 was even deposited in the Alliance Bank for paying the reward if such a situation arose at all. The company was confident that such a situation would never arise. Now, what happened? Mrs. Louisa Carlyle purchased the medicine. She consumed the medicine for 15 days as per the directions, but still she got a fresh episode of influenza. She sued the company for her £100 reward. Now, the company said a lot of things. The company said that there was no intention to enter into a contract with anybody. It was simply an advertisement which was used to boost the marketing of the smoke ball medicine. This was the first argument given by the company. Then, the second argument was that the offer was not made to any specific person. It was simply an advertisement. That's what it wanted to say. Third thing that the company said, acceptance by the offeree, acceptance by Mrs. Louisa Carlyle in this case, was not communicated back to the company. So there was no binding contract. But the court dismissed all the things, all the contentions of the company, and it said that the fact that the company had deposited this £1,000 in the Alliance Bank, that's a testimony to the fact that the company had a real intention to enter into a contractual relationship with anybody who accepted the offer. So the concept of general offer emerged because of the Carlyle versus Carbolic Smoke Ball Company case of 1893. And this means that an offer can be made to the world at large. It's a general offer and it's perfectly valid. In the case of a general offer, there is no need to communicate acceptance to the offerer. Merely fulfilling the terms and conditions of the contract will be enough to be considered a binding contract. You see how interesting this is? And it's a landmark case. Just as in India we have Maneka Gandhi case or the Keshavananda ruling, this is a case which is always cited in English law, in case of commercial disputes, obviously. Next, we come to the second thing, consideration. What is consideration? We already know, something in return. Now, mutual consideration is a must in any contract. Mutual consideration means what? When I give you something, you must give me something in return. As simple as that. There is only one exception to this hard and fast rule about mutual consideration. Registered and written instrument out of natural love, it's not void, even though there is no consideration. Like, for instance, gift. I hope you remember in the last chapter we discussed that in many cases we don't even need a consideration. When our parents give us their inheritance, when our parents give us their money and jewelry or whatever they have, we don't pay them back. That's a transfer made out of natural love, and it's not void. It's perfectly valid. It's called a gift. Consideration must be real. It should not be illegal, immoral, or opposed to public policy. These are general facts that you need to just read once. And there is an important case law. You need to remember this by heart, I guess. Durga Prasad versus Baldev. This was a case of 1880. What happened? The plaintiff, in this case Durga Prasad, he had built a shop at the request of the district collector in a town. Now the shop was constructed with a lot of money, with a lot of decoration. And the plaintiff, what he did, he gave the shop in rent to another person, who is Baldev in this case. And the defendant, Baldev, promised to pay 5% commission on all the items sold. Why? Because huge amount was spent for decoration of the shop. But subsequently, the defendant, Baldev, he failed to pay the commission. And Durga Prasad, or the plaintiff, he initiated an action against him. He wanted to recover the commission from him, the 5% commission on each items. I hope you know what is the meaning of a plaintiff and a defendant. Plaintiff is the person who lodges the complaint, in this case Durga Prasad, and defendant is the person against whom the complaint is filed, in this case Baldev. Now you see, Durga Prasad said many things, but the decision of the court was that the shop was constructed on the request of the district collector and not on the desire of the defendant. Baldev didn't ask Durga Prasad to decorate the shop with such a large amount of money. It was done on the request of the DC, district collector. Hence, there is no valid contract to pay the consideration. Okay. Next, we come to two important things. First of all, the capacity to contract, and then consent. Capacity to contract: any person who is above 18 years of age, who has a sound mind, and the person who is not disqualified by any law in force, and the person who has a rational judgment. In fact, the fourth point is a repetition of the second point, but nevertheless NCERT is given it like this. So you need to remember these 4 points. It's absolutely easy. And the ones who are disqualified from entering into a contract are the ones who are the minor, who are children below 18 years, the person with unsound minds, idiots and lunatics and drunkards, and the persons who are disqualified by any law in force, like foreign sovereign. Insolvents means a person who is bankrupt. Such persons are also exempted from entering into contracts. Convicts, the persons who are accused of crimes. Or corporation and barristers. Corporation as in somebody who works in the government, and barristers means lawyers, we all know. See, these two things, barristers and corporation, it's not applicable in India. It's applicable in UK back then. And also alien enemies, the ones who doesn't belong to our country, they cannot enter into a contract with somebody in our country, simply like we can do. These are the persons who are disqualified formally. Next, we come to consent. When two persons agree on the same thing in the same sense, it's called a consent. I am signifying to you my willingness to do something, and you are agreeing to this. Apart from being an agreement, this is also a consent to my offer. And consent should not be obtained by coercion, undue influence, misrepresentation. I cannot say wrong things to you. I cannot lie to you about something, about the terms and conditions of the contract. Then the consent is obtained by fraud and it's invalid. It should not be done by mistake too. Next we come to unlawful agreements, apart from which you often get a lot of questions. What are unlawful agreements? Whenever the object of an agreement is to perform an unlawful act, the contract is unenforceable. Alright? Objects of agreement should not be illegal, immoral, or opposed to public policy. There are two examples of unlawful agreement. One is a wager, another is a contingent contract. You see, there is only one example. In fact, wager is the example of the unlawful agreement. Contingent contracts are perfectly valid. Let's see what happens here. What happens in the case of a wager? Wager is a contract where one person promises to pay the other money on the happening of an uncertain future event. Simply remember wager as a bet. Suppose there is an India-Pakistan match. What happens here? There is A and B. A promises B that he will pay rupees 1000 to B if India wins, and B promises to pay A 1000 rupees if India loses. What is this? This is simply a bet, and it's invalid. It's an invalid contract. It cannot be enforced in a court of law. Suppose if A refuses to pay B 1000 rupees, B cannot approach the court to enforce this agreement. That's why we call wager an illegal contract. This is invalid. There is a reciprocal promise involved. We have seen how. A promises B to pay money if India wins. B promises to pay A the money if India loses. Now, third parties definitely don't have an interest in a wager, and a wager is contingent in nature. Contingent means conditional. It's a conditional contract. It's a contract to do or not to do something on the happening or non-happening of an event which is collateral to the contract. Here, such agreements, first of all, they are enforceable by law and they are perfectly valid. There is no reciprocal promise involved here. Third parties do have an interest in contingent contracts, and contingent contracts are not wagering. They are not bets. Like, for instance, B will sell the farmland if B wins the case. Here the condition is winning the case. B wants to sell his farmland to A if he wins the case. Here, winning the case is a condition on which this entire contract of B depends. This is a contingent contract. Alright. Next we have discharge. Whenever we enter into a contract, mutual obligations are created. And discharge means termination of the contractual relationship. When mutual obligations of the parties to a contract are fulfilled, the contract comes to an end. It becomes discharged. It is discharged. And discharge can be in 6 ways. Discharge by performance, discharge by agreement or consent, discharge by impossibility of performance, discharge by lapse of time, discharge by operation of law, last, discharge by breach of contract. In one single page, you have all the discharges written, so it won't be a problem at all to remember it. What happens when a discharge gets fulfilled by performance? Both the parties to a contract performs their duties, obligations and promises. The contract gets discharged. The contract comes to an end. I will pay you money for doing something. You do my work, you give me a service, I pay you money. This contract is discharged in this way. That's discharge by performance. Next is discharge by agreement or consent. Now this has 6 things further: novation, rescission, alteration, remission, waiver and merger. You need to pay attention to this part, little complex part, but it's alright, no problem. What happens in novation? Novation means a new contract is substituted for an old contract. We cancel an old contract for a new contract. That's novation. In the case of rescission, certain terms or all terms of a contract are cancelled because of reasons perhaps. In the case of alteration, certain terms are altered with the mutual consent of the parties. You must write mutual consent in case of both alteration and merger. Then remission. In the case of remission, there is an acceptance to a promise, but not in full terms. Acceptance is made to a lesser fulfillment of the promise. For example, Vikas takes loan from the bank and he promises to pay 14% interest. Then because of some incidents, Vikas cannot pay the 14% interest. Now what happens? There is a remission where Vikas will now pay 7% interest. So you see, acceptance is made to a promise. So Vikas is paying the interest, but not in full terms. The acceptance is made to a lesser fulfillment of the promise. He's now paying only 7%. Next, we have waiver. Waiver means parties abandon their mutual rights. Last, merger. Certain terms of a contract, or all terms, they are merged with another contract. Maybe the old contract became obsolete, or because of some other reasons, and this has to be by the mutual consent of parties. Don't forget this mutual consent in case of merger and alteration. Bas, nothing else in the case of discharge by agreement or consent. Next, we come to discharge by impossibility of performance. Contracts can also be discharged by way of impossibility of performance. There can be some situations where the performance of duties and obligations becomes impossible. Performance of a contract can be impossible then. This is called discharge by supervening impossibility. It can be by 5 ways. First of all, destruction of the subject matter. If I was supposed to sell my car to another person, say B, and in the way I meet with an accident, my car is destroyed in a bad way, or perhaps there is a lightning on my car. This is a very weird example, but still, in the case my car is destroyed, as a result my contract to pay B the not to give B the car, it becomes invalid. It's impossible to perform right now the contract. Death or incapacity, 2% enter into a contract, either of the parties dies, then the contract is discharged by impossibility of performance. Outbreak of a war. Now, war is an extraordinary situation. In this case, contracts gets discharged by impossibility of performance. Or perhaps non-existence of state of things having an effect on the contract. Like for instance, there was a question in my exam where Rohan was about to lease his balcony because there was a huge parade which was to take place in front of his house. Now, on the day of the parade, there was a lot of storms and rain. That's why the parade itself could not take place, and he could not lease his balcony for that. There is no mistake of Vikas in this, Rohan in this. He couldn't perform because of the impossibility of the circumstance, non-existence of state of things. Then change and amendment in law. Suppose there is a change in the contract law and there are certain things that are altered, then we cannot perform our contractual obligation. In this way, contract gets discharged. Next is a very interesting concept, discharge by lapse of time. Now, time is a very significant event in case of a contract. There is a concept of limitation act. A contract should be performed within a specified time. That's a period of limitation. If the contract is not performed within the specified time and the other person doesn't take an action within the stipulated limitation phase, then the person is deprived of his or her remedy. Now, you will be able to explain this fully if I give you an example. A and B are entering into a contract. Suppose. Now, A promised to pay B 50,000 rupees within 2 weeks, and the limitation period was 4 weeks. Now, within 2 weeks, A doesn't pay 50,000 rupees to B. Now, within the next 2 weeks, B has to resort to some remedy. Maybe B will approach the court, or B will ask or remind A once more to pay the money to him. If B doesn't do anything within the next 2 weeks, which is the limitation phase, limitation time, then the contract gets discharged, and after 4 weeks, B cannot legally do anything to A. B cannot legally ask for the money again from A. Then B is deprived of his or her remedy. The contract gets discharged by lapse of time. You see how interesting this concept is? Then we have discharge by operation of law. In this case, there is no mutual consent in time of discharge. Perhaps either party dies. Insolvency means the person becomes bankrupt, loses everything the person had. Merger means we have already discussed merger right here. We know what merger is. Merger means certain or all terms of a contract are merged with another contract. This can happen in the case of operation of law. You see, these are very technical things. You need to remember this. And the person or the contract becomes obsolete because of some unauthorized alteration of terms and conditions. In that case too, in these 4 instances, contract gets discharged by operation of law. Breach of contract. There can be a discharge of contract by breach or failure of the parties to perform the obligation. Breach. Everything about breach is written specifically in section 73 of Indian Contract Act of 1872. When a party fails to perform its part, then the aggrieved party can receive compensation or damages. That's breach of contract, failure to perform the obligation by a party. Now we come to the last part of this chapter, which is on damages. I hope you already know something about damages. If we formally define damages, then it's a remedy given by law as a means for the enforcement of the right of an aggrieved person. We generally award damages if a contract is breached. Monetary compensation is given to the affected party for the loss or injury incurred because of the breach. And there is a doctrine of retribution. Like for instance, I promise somebody else to pay a certain amount of money in exchange for a service. The person does his or her part, serves me in some way or the other, but I don't pay the money. The person has been at the person has incurred a loss because of my breach of contract. What happens? Legally, I have to pay the person compensation. I have to give damages to the person. I have to give money, perhaps more than what I was supposed to pay if I had not breached the contract. This monetary compensation is given to put the other party in the position it would have been if the contract was not breached. This is exactly the doctrine of retribution. Doctrine of retribution means we have to award damages to put the aggrieved party in the place it would have been if the contract was not breached. So that's it. Let's come back once more to the table of contents. Here it is. So we have done offer, we have done acceptance, we have done consideration, we have done capacity to contract, we have done free consent between parties, which is a must. We have done everything about unlawful objects, unlawful contracts, wager and contingent contracts. Contingent contracts, however, are not unlawful. They're perfectly valid. We have seen the discharges in 6 ways and we have done the remedies. We have also looked into this impossibility thing, discharge by impossibility of performance. That's it about this chapter. The chapter on contract is not easy, I know. You will require some time to understand some concepts, but I hope with repeated readings, if you see the video more than once, I think you will be able to understand much of the concepts here. So that's it for today. The next video is on criminal justice system. We will be doing it in the next video. So stay tuned to get my video notifications. Bye till then.